was opening a window in my rental house, and I put the peg in, thought it was in the side of the window to hold the window locked in place, and it came falling down. I went to catch it and pull it back up, but it didn't catch it, and it popped off the tip of my finger. And I was wondering, is there any liability, because it's just an old house with a lock that locks into the window on the side, a little spring clip, actually it is. A little spring peg is what it is.
Okay, so that kind of sounds like what we were talking about. Good question, Gordy.
Well, and I apologize, I tend to have a million questions that run through my head when I get calls like these, but it sounded like maybe you were renting a home and you went to open this window. Something that's really important to know in a premises case is in Tennessee, we use something that's called modified comparative fault. And so what that means is whether you think you are partially at fault or not, a judge is going to provide instructions to a jury when it comes to both of the parties involved in the case. And the parties would be you and then the premises owner. And a jury is going to listen to all of those facts, and oftentimes, unfortunately, you as the renter, you're going to have your hands in part of that premises. And so a judge is going to provide those instructions, and each of your attorneys are going to do their best to prove up your case. And a jury is going to listen to that, and they're going to potentially apply this comparative fault. And in Tennessee, as a plaintiff, if you're 50% or more at fault, then there's no recovery to be had in a case like that.
And one of the other things too in this particular case is, was that window to code? We would have to get an expert to see if it was at code or not. If it's not at code, there may be something called negligence per se. In other words, that since it wasn't to code, that essentially there's negligence going to be there.